All right, I've mentioned several times that Schaeffer's been through a whole slew of lawyers. I can count at least 6 that I know about. Robert John, Nelson Traverso, Peter Camille, Suzanne Elliott, Myra Sun, Michael Filipovic. There's another guy that was hired by the folks up in Alaska. So Suzanne Elliott was a gun grabber. She was a big-time Second Amendment, she was against the Second Amendment, wanted to grab all the guns from people in America. And I'm going through Schaeffer's appeal case. His appeal case number is different than his original case number. And Schaeffer told me to read all of his pro se motions. This particular pro se motion is only 5 pages long. Looks like he's trying to get new counsel because he did not like Suzanne Lee Elliott, who's a gun grabber. She's an Obama administration, let's get rid of all the guns and make tyranny come upon America. So she's, he didn't like her. I can understand that. Looks like this is dated December 30th. It was received December 30th, 2013. It's docket entry number 24. It's United States of America versus Francis Schaeffer Cox. Comes now. Schaeffer Cox, appellant, defendant, movement, and in propria persona respectfully moves this honorable court to appoint new counsel as required by Title 18 U.S.C. 4247 and urges this court to grant both motions for remand presently before the court. New counsel is required. Title 18 U.S.C. 4247 D provides that the person whose mental condition is the subject of the hearing shall be represented by counsel, and if he is financially unable to obtain adequate representation, counsel shall be appointed for him pursuant to Section 3006A, 18 U.S.C. 3006A. In the present case, Mr. Cox and his attorney, Miss Elliott, hold conflicting positions. Title 18 U.S.C. 3006A provides that the court may, in the interest of justice, substitute one appointed counsel for another at any stage of the proceedings. Miss Elliott has not reviewed the discovery in this case or the investigative reports prepared by Mr. Rollyport, private investigator for the defense team. Her position is based upon the evaluation made by Dr. Robin Ledoux. Dr. Ledoux's evaluation stems from her presumption that the events Mr. Cox described were too unimaginably outrageous for the government to have engaged in, leading her to conclude that Mr. Cox must be suffering from delusions. The position of Dr. Ledoux and subsequently of Miss Elliott is not shared by Mr. John or Mr. Port, who are more familiar with the evidence and the facts of the case, having successfully defended Mr. Cox from virtually identical charges in state court. Mr. John was also co-counsel of the federal case prior to trial. At least at this juncture, Mr. Cox and Miss Elliott are mortally conflicted, thus necessitating the appointment of new counsel, which is hereby requested. The court is urged to grant both motions. In spite of the fact that Mr. Cox and Miss Elliott hold conflicting positions, their respective motions are actually quite complementary. Mr. Cox seeks an order compelling the government to comply with their Brady-Kyles-Giglio obligations. Miss Elliott seeks to have Mr. Cox evaluated to determine if his claims are delusional. One request necessitates the other. Upon motion by the government, the district court suppressed recordings made by the FBI that supported Mr. Cox's claims that he had been attacked by informant Bill Fulton for refusing to plot a crime. That months later, Mr. Fulton had given Mr. Cox a death threat ultimatum that Mr. Cox was leaving the country with his wife and 2 young children as a result, that they had been stopped by informant $300,000 whore Gerald J.R. Olson, who used deception, sabotage of vehicles, and threats of harm from others to hold the Cox family in hiding in the upper room of a home in North Pole, Alaska, for a period of 21 days. And thus preventing them from carrying out their express plan of leaving in order to avoid any sort of trouble and out of fear for their lives. For a government attorney to know full well that Mr. Cox was telling the truth, suppress recordings corroborative of such testimony, then cloaking himself in the credibility of the United States government, assure the jury that there is not one scintilla of evidence to support Mr. Cox's claims, and that, let me back up on that, assure the jury that there is not, quote, one scintilla of evidence, end quote, to support Mr. Cox's claims, and that they were, quote, spontaneous fabrications, end quote, is no different than telling the jury there is blood on the pajamas when they know it's paint. Not only does this run afoul of Miller versus Pate, it demonstrates that the U.S. Attorney's Office is not acting in good faith. Is not acting in good faith. Given the prosecution's team's history of misconduct in related cases, coupled with evidence that points to undisclosed exculpatory evidence and ongoing ethics violations, and in light of the government's unwillingness to acknowledge their wrongdoing, past or present, an order to compel production and a hearing are in order. Any delay will not prejudice either party, and it would allow a fully developed record to be properly formed for this court to review should the case come back up. 3. Conclusion. Conflicting positions between Mr. Cox and Miss Elliott necessitate new counsel. Nonetheless, Mr. Cox's and Mrs. Elliott's motions are complementary. If this honorable court grants one, it should grant both, and appoint new counsel for the subsequent proceedings. Dated this 22nd day of December 2013, respectfully submitted, Francis Schaeffer Cox. Per register number 16179-006. And then it goes on to say, Certificate of Service. I, Francis Schaeffer Cox, hereby certify that on December 24th, 2013, served via first class U.S. mail one copy of this document in paper format to Assistant United States Attorney Serpent Stephen Scrocky, Assistant United States Attorney Joanne Farrington, and it gives their address, and also to Suzanne Lee Elliott. Alright, that's Schaeffer putting in his own pro se motion to get rid of this gun-grabbing attorney, Suzanne Lee Elliott.